Good day, students. Today we dive into a topic that is increasingly relevant in our digital age: intellectual property and copyright. In an era where content is created, shared, and consumed at an unprecedented pace, the principles of intellectual property and copyrights are more crucial than ever. This lecture will provide you with a comprehensive understanding of this concept, their importance in journalism and media, and the ethical consideration that comes with them. Objectives of the lecture. By the end of this lecture, you should be able to define intellectual property and copyrights and distinguish between the two. Understand the importance of intellectual property and copyright in journalism and media. Explore the fundamental principles of copyright law. Examine the role of journalists and media professionals in respecting and protecting intellectual property. Analyze the ethical considerations surrounding intellectual property and copyrights in the digital age. Understand the impact of social media and digital platform on intellectual property and copyright. Let's talk about the main part of the lecture. First is understanding intellectual property and copyright. Intellectual property, or IP, refers to creations of the mind, such as inventions, literature, and artistic works, design, symbols, name, and images used in commerce. Copyright is personal non-property and property rights of the author. Copyrights and related rights protects the rights of author, artists, musicians, broadcasters, and other creators in their literary or artistic works and rights. Copyright extends to both published, released, publicly performed, publicly shown, and unpublished work that exist in any objective form, which are written, manuscripts, typoscript, musical notation, oral, public utterance, public performance, sound or video recording, mechanical, digital, magnetic, optical, images, drawings, sketches, pictures, plan, film, television, video, or photo frame, three-dimensional, sculpture, model layout, constructions, and other forms. According to Jeremy Lipshutz in Social Media Law and Ethics 2021, copyright law is designed to protect the rights of creator while also promoting the progress of science and the useful arts by granting exclusive rights to author for a limited time. This balance between protecting creators' rights and promoting public access to knowledge is a cornerstone of copyright law. The Berne Convention for the Protection of Literary and Artistic Works, 1886, is one of the most important international agreements governing copyright. It established that copyright protection is automatic upon the creation of a work and does not require registration. This principle is crucial for journalists and media professionals, as it means that any original content they create is automatically protected by copyright law. However, the digital age has introduced new challenges to copyright protection. The ease with which content can be copied, shared, and modified online has led to widespread copyright infringement. As Lipshutz noted, social media platforms have created a new frontier for copyright issues, where the line between sharing and stealing content is often blurred. This is particularly relevant for journalists who must navigate the complexities of copyright law while also engaging with digital platforms that thrive on user-generated content. Importance of intellectual property and copyright in journalism and media. The importance of authors' rights for journalists has never been as clear as it is today. Technological and legal development in recent years have made journalists think again about authors' rights and led them to articulate more clearly their requirements concerning authors' rights. The development of new digital media affects the way journalists make a living and the ways their work is paid for. This is part of the widely discussed digital economy. But this new media also raise important questions about editorial independence, freedom of expression, media ethics, and quality. It is particularly important for the quality and credibility of newspapers, magazines, and broadcast media that journalists are aware of their non-material rights or moral rights, such as the right to defend the integrity of their work. Journalists need to know how to enforce these, where they are inadequate, and how they can be strengthened in the national and international law. The digital economy also means that online publications are available globally. It therefore increases the importance of cross-border rules governing authors, rights for journalists, as the other authors. Intellectual property and copyrights play a critical role in journalism and media for several reasons. Protecting creators' rights. Copyrights ensure that journalists and media professionals receive recognition and compensation for their work. This is essential for fostering creativity and innovation in the media industry. Promoting ethical journalism. Respecting copyright law is a fundamental aspect of ethical journalism. Plagiarism and copyright infringement undermine the credibility of journalists and media organizations. Ensuring access to information. While copyright protects creators' rights, it also includes provisions for fair use and public domain, which allow for the use of copyrighted material under certain conditions. This balance is crucial for ensuring that the public has access to information and knowledge. Navigating digital challenges. In the digital age, journalists must be aware of the copyright implications of using content from social media, blogs, and other online sources. The rapid dissemination of information online has made it easier for copyright infringement to occur, often unintentionally. The Digital Millennium Copyright Act, DMCA 1998, is a key piece of legislation in the United States that addressed copyright issues in the digital environment. It includes provisions for takedown notice, which allows copyright holders to request the removal of infringing content from online platforms. However, as Lipschutz pointed out, the DMCA has been criticized for its limitation in addressing the scale and speed of copyright infringement in the digital age. This highlights the need for journalists and media professionals to be vigilant in respecting copyright law while also advocating for reforms that address the challenges of the digital era. The universal principles of authors' rights are now enshrined in international treaties. These are administered by United Nations body, the World Intellectual Property Organization, or WIPO. The European Community has also agreed directives designed to harmonize aspects of authors' rights across the member states. For European authors, the most important international treaties are the Berne Convention for the Protection of Literary and Artistic Works, the Rome Convention for the Protection of Performers, Producers of Phonograms and Broadcasting Companies, the WIPO Copyright Treaty, YCT, the WIPO Performances and Phonograms Treaty, YPPT, and the Agreement on Trade-Related Aspects of Intellectual Property, TRIPS, administered by the World Trade Organization. These international treaties establish the basic principles of internationally applicable authors' rights, the minimum level of protection that signatory states must offer. They leave individual countries some flexibility in how they express this in national law, including the option of offering stronger protection. As a result, authors' rights legislation varies quite widely from country to country. European Union directives, in contrast, require EU member states to implement them in their national law. Each covers a fairly narrow area. A standard European framework for authors' rights will become clearer as the level of detail in the directives increases. The fundamental direction that authors' rights should take in Europe is still, however, in dispute. The choice is between the copyright system of the English-speaking world in particular and the continental approach of protection for the author. Fundamental principles of copyright law. A. Originality and fixation. Copyright protects original work of authors that are fixed in a tangible medium of expression. This means that the work must be independently created and have a minimal degree of creativity. For journalists, this means that their articles, Photographs, video, and other creative works are automatically protected by copyright as soon as they're created and fixed in a tangible form. B. Exclusive rights. Copyright grants creators exclusive rights to reproduce, distribute, perform, display, and create derivative works based on their original creations. This right allows journalists to control how their work is used and to monetize their creations throughout licensing and other meanings. C. Fair use. Fair use is a legal doctrine that allows for the limited use of copyrighted materials without permission from the copyright holder. Factors considered in fair use include the purpose and character of the user, the nature of the copyright work, and the amount and substantially of the portion used, and the effect of the use on the market for the original work. Journalists often rely on fair use when quoting from other works, using images or videos in their reporting, or creating reports and critiques. D. Public domain. Works in the public domain are not protected by copyright and can be freely used by anyone. This includes works whose copyright has expired, works created by the US government, and works that have been dedicated to the public domain by their creators. Journalists can use public domain materials without worrying about copyright infringement, but they must still ensure that the use is ethical and does not misrepresent the original work. Можно будет чуть-чуть побыстрее. Спасибо. E. Moral rights. In some jurisdictions, copyright law includes moral right, which protects the personal and reputational interests of creators. This right includes the right to attribution and the right to integrity, which allows creators to object to modifications of their work that could harm their reputation. For journalists, moral rights are particularly important when their work is published or modified by others. They have the rights to be credited for their work and to object to changes that could distort their original message. Copyrights versus author's right. A major difference between the copyrights and author's rights systems concern the question of who or what can hold primary rights in the created work. UK copyright law, for example, allows corporations to be recognized as authors. In contrast, continental author's right can only be held by real people. Authors merely grant rights to use the right works but can never lose their position as the legally recognized creators. The law of the UK and Ireland also state that where a work is created in the course of employment, the employer is the original owner of copyright in it, and the employee has no economic rights. The Netherlands operates a similar system. This is clearly not possible under author's right. This is one of the greatest challenges for European journalists, associations, and for the FAG. The entry of the new Eastern Europe member states will strengthen the position of journalists since the author's rights regime in these countries are based on continental law. Another challenge is that technical copy protection mechanisms such as digital encryption are increasingly used to prevent reprinting or electronic reproduction. Some have even suggested totally replacing the legal protection afforded by author's rights with such technical protection. Requirements for protection. Author's right in a work take effect as soon as the work is completed. Neither the Berne Convention nor the European directives allow states' law to require registration or any other formality for the applications of author's right. Article 3 of the Term of Protection Directive and Article 5 of the Database Directive, for example, stipulates that works merely have to be results of one's own intellectual intention in order to be protected. No other criteria might be applied to determine where work is protected. The widely used copyright notice, which is a C in a circle, followed by the name of the party holding the author's right and the year in which the work was first published is, therefore, not a condition for the protection of author's rights. Some countries outside Europe, which are not party to the Berne Convention, do stipulate formal requirements. If these countries have subscribed to the Universal Copyright Convention, this copyright notice gives some protection. And if legal action in the United States is possibility, registration with the U.S. Copyright Office is strongly recommended. In order to enjoy the protection afforded by author's right, a work must be original. Whether the work has any literary or artistic merit is irrelevant. It is sufficient for it to be an original piece of work. However, it must be expressed in a specific, perceptible form, whether in pictures, word, music, or material. Ideas per se are not protected. It is their expression that is protected as soon as it is fixed in given specific form. For example, let's look at the several examples, okay? The first one, a journalist has an idea for a story and takes it to the newspaper. The newspaper sees no advantage in working with the journalist but likes the idea. It engages someone else to develop the idea. The person who had the idea cannot do anything about this under copyright or author's law. The other example, a journalist who uses actual data taken from another article to write their own stories does not violate author's right. However, a journalist who simply takes a significant part of the article word for word is infringing the author's right. Чуть-чуть побыстрее. That is plagiarism. Author's right duration. In European Union member states, author's right in written and photographic works expires 70 years after the death of author. Some member states extend a period of protection to photographs that are not defined in those states as works. In Germany, for example, this protection lasts for 50 years after the photograph was taken or appeared. In other member states, all photographs are protected works. Article 1 to 4 of the EU Term of Protection Directives describes the term of protection in detail and deal with more complicated cases like jointly authored work and films. The importance of journalists' moral rights. The moral rights maintain a personal link between each journalist and their work, which is their creation and their brainchild. It is the result of creating process involving research, gathering of information, its selection and analysis, and reporting. As noted, the moral rights give each journalist the rights to be identified as the author of the work and to oppose any distortion, mutilation, or other alteration of their work or any other attack on it, which could adversely affect his honor or good name, which is Article 6b on the Berne Convention. It is vital that journalists retain control over what happens to their work. Journalists have a responsibility towards society. Guarantees of the quality and authenticity of a publication or a broadcast are preconditions for serious journalism. The public expects every journalist to adhere to these principles. Distortion or twisting facts, or even merely arranging them in a different order, can give a story a different spin, leading the world to misinform instead of informing. The author's right is to be identified means that readers and viewers know who ultimately takes responsibility for it. Strong moral rights guarantee the authenticity, quality, and integrity of work. This is an advisable link between moral rights and the ethic and independence of journalism. Within the commercial environments of daily newspaper business, magazine productions, and private broadcasting, as well as in the less commercial world of public broadcasting, moral rights promotes high ethical standards. These moral rights are generally inextricably linked to the creators, the author, and cannot be transferred or removed. In the UK and Ireland, however, it is possible for authors to waive moral rights, and they do not exist at all for works reporting news and current affairs. The FAG considered that these are the work for which moral rights are most important and that this law needs to be changed. Editorial changes that do not disturb the meaning, alter the factors, or change the journalist's intentions or context are permitted, however. The importance of journalist usage right. The fact that the journalist's content is needed for the use of their work is what gives them the power to stipulate conditions on that use, such as the payment, the type and method for use. For example, that the work may be reproduced in daily newspapers, in a radio broadcast, as an article, in an online service, as a book, and etc. The scope of the use, for example, that the work may be used only in an only in an initial print run, edition, or broadcast. The area of distribution or publication, for example, local, regional, national, or international. The duration of use. As an example, one of in the edition or broadcast or for a precisely defined period. This and other associated conditions such as questions of liability should be defined in a contract governing the use of the work. In some countries, individual written contracts are required, while in others, trade unions or professional associations have negotiated collective agreements that are binding on everyone who sign up to them. The unions can also provide model contracts and specimen terms and conditions of businesses. In some countries, collective agreements can set our minimum or recommended fees. Impact of social media and digital platforms on intellectual property and copyright. Social media and digital platforms have had a profound impact on intellectual property and copyright. These platforms have democratized content creation and distribution, allowing anyone with an internet connection to share their work with the global audience. However, they have also created new challenges for copyright protection, as content can be easily copied, shared, and modified without the creator's consent. One of the key challenges is the issue of content moderation. Social media platforms are often criticized for their inconsistent enforcement of copyright law, with some creators reporting that their work is frequently used without the permission or attribution. As Lipschutz notes, the sheer volume of content uploaded to social media platforms makes it difficult for copyright holders to monitor and enforce their right, leading to widespread copyright infringement. Another challenge is the issue of monetization. While social media platforms provide creators with new opportunities to monetize their work, they also take a significant cut of the revenue generated. This has led to concerns about the fairness of the revenue-sharing models used by these platforms, particularly for independent creators who rely on social media as their primary source of income. Finally, the issue of algorithmic bias raises important questions about the impact of social media on intellectual property. As mentioned earlier, the algorithmic curation of content can lead to the amplification of certain types of content while marginalizing others. This can have a significant impact on the visibility and monetization of original content, particularly for the creators from magazines communities, for creators from marginalized communities. In conclusion, intellectual property and copyrights are fundamental to the practices of journalism and media. They protect the rights of creators, promote ethical journalism, and ensure access to information. However, the digital age has introduced new challenges to copyright protection, particularly in the context of social media and digital platforms. As future media professionals, you must be vigilant in respecting and protecting intellectual property while also advocating for reforms that addresses the challenges of the digital era. Ethical journalism requires a commitment to upholding the principles of intellectual property and copyright, ensuring that creation and innovation continues to thrive in the media industry. And on the last slide, you can look up on some of the convention, such as I also noticed before, Berne Convention for the Protection of Literary and Artistic Works, 1886, World Intellectual Property Organization, Digital Millennium Copyright Act, 1998, Lessing L, Free Culture, How Big Media Uses Technology and the Lack to Lock Down Culture and Control Creativity, Penguin Presses, Samuelson P., 2016, Intellectual Property and the Digital Economy, and etc. I hope this lecture was very interesting for you, and I hope to see you next time. Bye-bye.